Good afternoon, everyone. Thank you for joining me for this seminar this afternoon on a 3-day weekend. I appreciate it. So as Irie-san said, this is the second of a two-part series on the impact of examination or the impact of U.S. rules and case law on patent translation issues. This is the second of that two-part series. And as this first slide says, and as I put the title in the both in the handout and the pre-seminar exercises, today's theme is particularly focused on U.S. case law and indefiniteness and other issues in claims that have been translated from Japanese. And also, as Irie-san said, I welcome your questions and at any time during my lecture, my seminar. In fact, a seminar is supposed to mean, the difference between a lecture and a seminar is that a seminar is what distinguishes a seminar from a lecture is that the attendees, the participants, ask questions of the presenter, of the lecturer. So please ask questions. That way we can say that today's event is a seminar rather than just me being a lecturer and presenting a lecture. Okay, so that's by way of introduction to today. I think this is well, let me add to my introduction for today's seminar by saying that over the years as a translator and patent practitioner, someone who handles U.S. patent applications based on Japanese original specifications, I have heard of decisions by U.S. courts and other venues that I will describe in a moment. Over the years, I've heard of some famous cases, but for today's lecture, I decided to dig into some different sources to try to find examples of issues where translation has had an impact on the patent application in the U.S. and then even the decision that the legal decision that that the translation involved ended up having what is called a precedential impact on U.S. patent prosecution. Precedent means the case is important enough to change policy in how patents are examined, and in some cases, what is allowed by the Patent Office rules. So it's a very interesting topic, and my point is that I was surprised at how much information is out there about or available to about cases in which Japanese translation had an impact on U.S. patent prosecution, etc. So that's what we will be looking at. So to start off, in a sense, I will be repeating what I just said in my introduction here, but today's seminar topics are just three. The first is, very briefly, in just a few minutes, I will describe the difference, a key difference between U.S. and Japanese judicial systems. And the bulk of today's presentation will be this, a sample-based look at the history of Japanese translation issues in U.S. patent jurisprudence. Jurisprudence is just a fancy word for saying the procedures and outcomes of judicial proceedings in courts, and then in some cases within the patent office, which I will talk about in a moment also. And then the third topic is shorter. I will look briefly at how grammar, patent grammar in particular, appears in federal district court decisions involving patent disputes. So again, I feel that's a rather interesting, somewhat surprising aspect of U.S. patent practice, that the courts themselves they discuss in their decisions grammatical issues. And of course, we as translators need to always be aware of grammatical issues. And I say patent grammar because even though the grammatical issues are based on everyday English grammar, the particular decisions have an impact on patent prosecution as well as enforcement. So continuing with the PowerPoint here, and then in a moment I'll turn to today's handout, the Word file, but let's start with this first topic. So I titled this slide Judicial Patent Claim Interpretation, and this is from a previous presentation, so I have some Japanese equivalents of the title. This says Tokyo Seikyu no Shiho Teki na Kaishaku. So what's the point is to compare the foundational principles of the Japanese system versus the US system. And in order to do that, we have to look at the origins of both systems. And it turns out that the system in Japan is based on civil law, what is called civil law in English. And that comes from Germany, apparently, as far as the Japanese modern legal system is concerned. And then as far as the US legal system is concerned, that, of course, is derived from England, because America was a colony of England. And whereas the German system is based on what's called civil law, the British system is based on common law. And the key difference is that civil law is more focused on the laws per se, the laws themselves, the laws that have been passed by the legislative bodies, whereas common law systems are based both on the legislative, the laws themselves, but in addition, the laws themselves are created by legislative bodies. But in addition, common law systems are based very heavily and influenced very strongly by case law. And case law is the body of legal decisions issued by judges, and in the case of the USPTO, by officials at the Patent Office who have the legal authority almost of a civil trial judge. So as far as patents are concerned, the difference, and I only have this in Japanese, this is a translation from an English description in English of the of the impact of the difference between civil law and common law in terms of how claims are interpreted. I don't know if this is very clear. Tokyo Genja ni hei kohei na hogo no hani o kakuho. So the idea here is that under a civil law system, the scope of protection granted to the patent owner should be fair to the public. And so the idea is that, in my opinion, the sense I get from this is that the focus in patent prosecution, when a patent application is filed in a civil law country, the focus is on ensuring that the claims are reasonable and not the scope of protection is fair to the public. Whereas in a common law country, like in common law jurisdictions, we say England and America, it says this is oyake ni hogo no hani no 確実性や意外のないことを確保する. So this is, the idea is more that the claims are already a right of the patent applicant, and then the idea of the goal of prosecution is to make sure that the scope is clear. There's nothing about fairness, but what's the focus? I shouldn't say there's nothing about fairness, but the focus is on clarity of the scope, and that there's nothing that would be unclear to the public, or igai no nai, so nothing surprising to the public about the scope of the claims. So there is quite a significant difference, and I hope I don't seem like I'm spending too much time on this, but it's a very important point, because Japan is still it's a civil law based system, and the US is common law based, and it really leads to significant differences in how claims are examined between the two jurisdictions. So I put a question mark here because I feel like this difference is not understood enough, both by Ben Ricci and then translators as well. I think it's worthwhile to know this difference. So now I will turn to the handout. And just to add a few comments further to the presentation slide there. Well, in addition to the comments, I'll recap. So the key difference is that Japanese system, whereas the Japanese system is structured on civil law, the US system is structured on common law. And what that means, most importantly, is here. Decisions of courts and tribunals have direct impact on executive functions. What does that mean? Well, decisions of court, that's Saiban Shou no hanketsu desu ne. But tribunal just means, rather than a court, it means in this case you'll see in a moment, but the Patent Trials and Appeal Board, within the Patent Office, there has been a patent trial system, in particular, a system for invalidating patents within the USPTO. And that has been in place since the new patent statute went into effect in 2012. That meaning a specific system for invalidating patents. So, and those are called trials. In the past, there was an appeal board. There has always been an appeal, or for most of the history of the Patent Office, I believe, there has been an appeals system where the applicant can appeal from an examiner's final rejection. But the idea of having a trial for an invalidity within the Patent Office is new as of 2012. So, and the Patent Office judges, they're called judges, are legally, they're considered part of what is called a tribunal. And when I say impact on executive functions, I just mean the Patent Office itself and the rules it makes and the guidance and instructions the Patent Office gives to examiners for examining applications. So the point is that in a common law country like the US, case law is very important, and it very quickly can have an impact on not only courts, but on the USPTO itself. And I add that here. The USPTO adopts court and PTAB decisions into rules and policy. I won't belabor this. I've said I've made this point elsewhere, but I just touched on this a bit in the PowerPoint slide, this previous slide, where I pointed out that whereas in a civil law tradition, the emphasis is on fairness to the public, in a common law system, the emphasis is on clarity of patent rights guaranteed to the individual patent owner. And I believe that difference has an impact on how claims are examined, and these terms are not my terms. They're in Wikipedia. They've been in this this term central claiming versus peripheral claiming. It's also part of this difference between the U.S. system, which focuses on the claims themselves, versus civil law in Japan and other patent systems that focus on examining in light with the specification being considered as the claims are examined. That's what a central claiming regime is. Excuse me. And so I've made this point before that the US is peripheral, and this has a huge impact on how patent applications are examined and how examiners write their rejections. And I still think it's the source of a lot of misunderstanding between Japanese patent attorneys and U.S. patent examiners. I encounter this every day in my job. That the examiners in the U.S. are very focused only on the claims and defining very clearly the scope of patent protection based on the claims alone. And my point here is that this difference between peripheral and central claiming has its origins in the difference between a civil law system and a common law system. Okay, so let's move on to the second topic today. That's the first topic is the difference in the two jurisdictions. Oh, before we do that, I just wanted to show everyone very briefly where I got a lot of the information for today's presentation. And also just to make clear what the origin of these federal case decisions is. And that is namely the district courts. So in the US, all patent disputes are interstate. They're not there because the patent right is a federal right. It's rare for the federal government to grant rights to individuals. I don't think there are many other types of rights that have this power. The right is valid throughout the entire country. And for that reason, any patent dispute has to be tried in a district court. And this map shows all of the US district courts. There are, I think there are, this makes it look like there's only 11, but that might be right, that there's only 11. And then plus there's the U.S. Court of Appeals for the Federal Circuit. I think a lot of you know about the Federal Circuit. And then there's, of course, the Supreme Court. And these two, these are courts of appeals. The other district courts are not courts. Well, they can all conduct appeal proceedings as well. No, I'm sorry, they cannot. You know, the Federal Circuit is the Court of Appeals for all the district courts. And then if the ultimate appeals court in the US is the Supreme Court. I will provide these slides to everyone today after today's lecture, and you can click on this, and these are hyperlinks in here. But unfortunately, if you go to the Court of Appeals for the Federal Circuit, you can't. It's not a very useful website. You can't do any searching really of the case law for free. The public cannot, and there used to be ways to search the Federal Circuit decisions, but it apparently is no longer possible. And so I guess it's not opening. Sorry about that. But if you're interested in looking at, a description of the Federal Circuit, you can find it there in the Supreme Court as well. On the other hand, the other source of case law is within the USPTO itself, and that's here on this slide. I've indicated where one can go to look at proceedings that are called appeals, or as I just said, the trials for invalidity that were conducted by the Patent Trial and Appeal Board. Its nickname is pronounced PTAB. And this is a very, very interesting source of information. That's where I got many of the cases that I discovered for today. That's where I discovered several of the cases that we're going to look at today. So I invite anyone who's interested to look at this or to go here, and you can do text-based searches on all of the decisions. This is right now, the default is to limit it to just 1 month's worth of decisions, and there were 720 decisions made. I'm sorry, 712. But if you undo that, you get the entire corpus of decisions. And it turns out there's over 181,000 decisions have been made in the history of PTAB. And so by doing a search here, I came on specific keywords involving translation and some other keywords that occurred to me. I was able to discover some fairly interesting cases, and those are the subject of today's, both the pre-seminar exercises and my presentation itself. And and then there's one, so let me just review here. So patent cases, court decisions are issued by district courts, and then if there's an appeal, the decision on the appeal is issued by the Federal Circuit, and then if that decision is appealed, the decision is issued by the Supreme Court, the appeal decision. Then within the Patent Office, is the Patent Trial and Appeal Board, and as I just showed you on their website, you can search their decisions, and that's another source of patent application and invalidation, appeals from rejections and applications, and then trials for invalidity within the Patent Office. And one other source is just this, which is part of the Manual of Patent Examining Procedure, the MPEP. And if you look at the Manual of Patent Examining Procedure online, you can find this Appendix 2, list of decisions cited. I've only copied an image of the first few cases on the list. It's about a 6-page list, A through Z, and there are probably dozens and dozens of cases, maybe a couple of hundred or more cases that are actually discussed in the MPEP itself. And all of these cases in the MPEP are what are called precedential. And in my opening remarks, I use that word precedential, and it's a legal term that means that the decision was so important that it had an impact on rules in this case, in the Patent Office. So, and then I also have a hyperlink in this slide if anyone wants to go to this list. Now, why am I talking about the list of decisions cited in the MPP? Well, the reason is because of this case that is very important in the MPP, and it involved an old patent issued to a Japanese company in the 1960s, so almost as old as I am. Excuse me just a moment. And this case is called In Re Oda, and the reason is because the first named inventor in this case was a Mr. Oda. And so this is in the handout. Everyone has a copy of this. But I thought it was very interesting that in an application filed in 1963 by a Japanese company, there was a translation problem, and it led to a long series of back and forth exchanges with the examiner and then an appeal process in the patent office. And those remedies failed. And so ultimately the applicant appealed to in the predecessor to the Federal Circuit. The predecessor, you'll see in the slide in just a moment, but the predecessor to the Federal Circuit was called the CCPA, the Court of Customs, Patents, and Appeals. But before I jump to that, here, I have it here. I'm sorry. The United States Court of Customs and Patent Appeals, CCPA, predecessor to the Federal Circuit. I have it there, not in the slide. But anyway, let me just talk very briefly about the translation issue. I think it's rather fascinating. Especially to me, I wouldn't have thought that a Japanese applicant in the early 60s would have gotten a translation in and filed an application, had it issued as a patent, and then realized there was this mistake, and then went to all this great trouble to try to fix the mistake. To me, that I just had no idea that these kinds of procedures were going on between Japan and the US even in the early 60s. So basically, I will just show this slide very quickly, this in Ryota. Here it is in the slides. This is the actual patent that issued. It's just 2 pages. This is the entire patent. It's, as you can see, it involves a lot of chemical description of the chemical makeup and structure of what ultimately are dyes, I believe, that were used in a special kind of printing paper. I think it might have been for making copies. There were no photocopying machines yet, but it was probably for what were called mimeograph machines. But anyway, you can see here, so, Ryohei Oda and in Kyoto, and then there was an inventor in Nagasaki and Nishinomiya, and 2 inventors, and the applicant was Kanzaki Seishi, Kanzaki Paper Manufacturing. And the problem was here in the third dependent claim. That claim said that the particular chemical compound that they're called phthalides, I think is how it's pronounced, is nitrated with a mixture of sulfuric acid and nitrous acid. The whole problem was this word nitrous. And what is the problem more specifically? It turns out that nitrous acid and nitric acid, maybe if any of you participants are specialists in chemistry, you would understand this immediately, but it turns out that the simple distinction between nitrous and nitric is extremely important chemically. It turns out that nitrous acid is a weak inorganic acid, whereas nitric acid is extremely reactive. It's an oxidizing agent, and it's used to make fertilizers, explosives, and even rocket fuels. When I first read this, I thought that the applicant, Kanzaki Seishi, their application mistakenly claimed or recited nitric acid, which is explosive, and they wanted to recite nitrous, but it's actually, which is used for making dyes, but it turns out it's the opposite. I guess their process actually required this highly reactive oxidizing agent. And it's interesting, I looked in the dictionary, both of these are shosan, but I guess they say shosan to distinguish nitric from nitrous. But in the dictionary, they both say chiso no. でもこれは酸化の窒素で、これ合化の窒素. So this is the, I guess, I'm not sure where 3 valences, or there's 3 atoms, or there's 3 electrons in the valence. I don't know enough about chemistry, but the key difference is that I guess how many atoms or how many electrons are occupying the whatever orbital of the nitrogen atom. But anyhow, this difference is really important, and the patent issued with the incorrect translation nitrous acid. So, and it turns out that the patent attorney knew that there was a mistake. He realized that there was a mistake after the examiner allowed the case, and he thought, as is even now we patent attorneys or agents would think, you can correct this kind of mistake by what's called a Rule 312 amendment. It's an amendment to make, as I put here, post-allowance non-substantive changes that are not material to patentability. And what is supposed to happen is that you submit, it's basically to correct typos or to make changes that are to correct obvious problems, and then the examiner is supposed to just enter the amendment and everything's okay. Well, it turns out the patent attorney tried to file a Rule 312 amendment, and the examiner said, no, I'm not going to enter this amendment because this change from nitrous to nitric is substantive and it's material to patentability, and so I can't let you get away with this. So the applicant resigned to not being able to correct this error by a Rule 312 amendment. And so instead, they filed a reissue application. And you can do that within 2 years after a patent issues. So, but unfortunately, even the reissue application was rejected because the examiner said, it was probably the same examiner, said that this is adding new matter. I'm sorry, adding new matter to the case. So Kanzaki Seishi was very, they didn't want to give up, and they worked, they put in a lot of effort and didn't give up. And so they appealed the examiner's rejection of the reissue application to what is the predecessor of PTAB, the Patent Office Board of Appeals. As I said earlier, before 2012, the Patent Office had this appeal board, which was for the purpose of appealing from final rejections, but there was no mechanism or system within the Patent Office to invalidate patents. So that's why there's no word trial here, whereas, well, I already described it. PTAB is, this T stands for trial. And that's new. But anyway, so not to go on too much about this, but the point is that, or the outcome really is that the board, the Patent Office still or sided with the examiner, and they said they rejected the appeal, and they said, or they upheld the examiner's rejection. So the application, the reissue application stayed rejected, and Kanzaki Seishi was still not able to correct their patent. So finally, they spent the money and went to all the time and trouble of going outside the Patent Office and filing an appeal with the CCPA at what at the time was called the CCPA. And as I've said, it's the predecessor to the Federal Circuit. And finally, doing that led to a reversal of the examiner's rejection. So that was a huge deal. That was had a very significant impact on U.S. patent prosecution. And as I say here, the decisions of courts, now tribunals within the Patent Office, but courts are outside the Patent Office, can have an impact on the USPTO. So they adopt the court decision. So what happened was the CCPA reversed, and then the USPTO adopted the result into their examination policy. And they said, and that result is here now in the MPEP in this section 216307. Amendments to an application which are supported in the original description are not new matter. And there's a couple of sections there. And the second one says obvious errors. An amendment to correct an obvious error does not constitute new matter where one skilled in the art would not only recognize the existence of the error in the specification, but also the appropriate correction. This came from that case in Re Oda. So I think it's interesting. So just to review this very briefly, what happened was the translator made a mistake, but it's a very, we would call it an honest mistake. It was a mistake not out of negligence probably, but just an easy mistake to make, using the word nitrous instead of nitrate. And that led to the applicant wanting to be sure that their patent was enforceable and going through these procedures within the patent office to try to fix the problem, and none of them worked. So finally, they went outside the patent office into the courts and did a civil proceeding in the courts and got a reversal of the rejection, and that had an immediate impact on U.S. Patent Office, USPTO policy, examination policy. And that impact was, if the error is obvious and its correction is obvious to a person skilled in the art, then the examiner should allow that correction. So the point is for translators, first of all, to understand how important these small errors can be in terms of the enforceability of a claim, and to what lengths the applicant might go to and how much time and money they might spend to correct the problem. And then lastly, to know that in extreme cases, it might be possible to fix the error. If it's the remedy, the way of fixing the error would be clear, obvious to a person skilled in the art. But that doesn't mean we shouldn't be careful just because obvious errors can be corrected. But again, I think it's important to bear in mind just what kind of impact this translation had on this particular case. Any questions so far? I'm not seeing any. Okay, so then I'll move on to another precedential case. So right now I'm looking at we've looked at one of the early precedential cases that involved Japanese translation. Now I'll look at a much more recent precedential case, Ex parte Miyazaki. And that particular case was in today's pre-seminar exercises. I think before I look at the translation issue, I will just briefly explain Ex parte Miyazaki. Let's see, I think I have, yes, I have it in my slide. Let's look at the history of this case. This is, let's see. So I've got the information here in the slides, the patent application number and the publication number. The title was Large Printer. I think you'll see from, or I don't think, I know that everyone will have the title there before them, I think, because it's in the claim itself, Ogata Purinta. I'll talk about the problem with saying large printer in just a moment. But first, I want to just, I thought I would show via these slides the very extended protracted means made unnecessarily long prosecution of this case. This is a public information. I downloaded it from the USPTO from what's now called Patent Center. So you'll see that if you look at this case, you'll see that it ultimately was abandoned in 2009. But if you look at the filing date, it's 1999. I'm sorry. So it was filed on August 30th, 1999, and finally abandoned in 2009. That means that the application was pending for 10 years. And to underscore how long the prosecution was, I downloaded the whole history of it. here's 2009 where abandonment appears, and it goes on and on and on and on and on. This is going backwards to 1999. And the point is that this prosecution dragged on and on and on, and the history contained the following: 4 final rejections, a continuing application, which at the time was called a continued prosecution application because RCEs did not exist yet prior to 2001. And then when RCEs came in, the applicant, Seiko Epson, filed 2 RCEs, and then they also filed an appeal. So that's what I mean by a protracted prosecution. It was extended through over a very long period of time through many procedures. And it goes without saying that they must have spent a lot of money to try to get this case allowed. I won't go into all of the details of what the attorneys tried to do to fix this case, but one thing they did was they added a limitation from the application. Well, let's look at the problem now. Let's look at the problem since we did it as homework. So here's claim 1. The problem is in claim 1. And it's specifically in the phrase that I asked everyone to translate. In particular, 作業者が立った状態で、前期労使の交換及び合成厚紙のセットを含む教師のための処理を行える高さに配置され。This is the whole problem. This is what they spent 10 years trying to fix, actually. And the reason I asked everyone to look at this as a translation issue was to investigate whether the translation could have, a better translation could have helped this case. Let me see if I have the, yeah, I don't have the English. I thought I put the English in the, oh, I did. I put it in the handout. Just a moment. Well, I didn't put it directly in the handout. I'm sorry. It's something that, it's immediately available on the Patent Office. But so when the applicant, the inventor's name is Miyazaki. At the time, everything was done in the name of the inventor. This was pre-2012. But the applicant, the company footing the bills was Seiko Epson. And the PTO's decision, the appeal board's decision was to uphold the examiner's rejection after all of the RCEs and continuing applications, and they appealed, and the examiner would not allow the case, or the appeal board upheld the examiner's rejection. And this is just what the appeal board said. The examiner rejected the claims because the claims relating the height of the paper feeding unit to a user's height are unclear. So the whole problem is that this idea of saying 作業者が立った状態で、この処理を行える高さに配置される。So it's saying that this sheet supply unit, 給支部がこの高さに配置される. Well, how do they define the height? Well, the height is it's relative to the operator's height. That's the problem. It was a relative limitation. And whereas there are other ways that could have been availed of to fix this problem, the prosecuting attorney, or probably the applicant, instructed the U.S. attorney to do this. They just threw in this phrase from the claim. Oh, the user, or the sagyosha, is about usually on average 170 centimeters tall. So they put that in there to try to fix the problem. And it turns out that that was no good. It did not fix the problem. So the appellant means the applicant said that this is putting this 170 centimeters tall of average or approximate height makes the claim definite. And that's what they are asserting here. But the board said it's still indefinite because the manner in which the claims recite the height of the paper feeding unit are in relation to a user's height, so it's ambiguous. And then the conclusion was, we agree with the examiner that claim 1 is not sufficiently definite. So going back to the homework, however, so I thought, well, let's look at this key phrase that Seiko Epson spent basically 10 years trying to cope with, in order to get a patent. And see if there was anything that could have been done with the translation per se. And my conclusion is that, unfortunately, if you do a faithful, 100% faithful translation that is 100% faithful to this original Japanese, you can't really fix the problem. I did my best here. I said the sheet supply unit is disposed at a height that allows an operator in a standing state to carry out processes for sheet supply. This is not really important, this is just filler. We don't really need to worry about that. I'm just gonna, it's not really important for interpreting the claim. But if we say it's disposed at a height, so here's the key issue. We have okonaeru yo ni, but we also have okonaeru. And I thought it's interesting that I thought maybe if this okonaeru yo ni applied to both features of the Kyushibu, of the sheet supply unit, then maybe the translator could have said it's formed or designed or configured in such a way that the height can be, or as to be disposed at a height that allows the user to do this. But unfortunately, we have a parallel construction here where we have okonaeru, and it doesn't say okonaeru yo. It does not say okonaeru yo ni here. It just says okonaeru takasa ni haichi saru. And then we have katsu. So this katsu is very strong, and it makes this construction parallel. So the translator cannot, I don't think, can fix this because of the parallel construction. So we have okonaeru takasa on the one hand, and then we have okonaeru yo ni keisei sareteru. But that only applies, this okonaeru yo ni keisei sareteru only applies to this recitation. So as far as I tried to, I thought it would be interesting anyway for all of us to look at this as translators to see if there was some way to fix this. And I know that some of the participants who did today's homework, pre-seminar exercises, realized this problem. And I think one or two persons, yeah, this translator threw in the word adjustable, which would have solved the problem, actually. As far as I can tell, this would have solved the problem and saved maybe about 8 years of prosecution and probably thousands and thousands and thousands of dollars in attorney's fees and USPTO fees for doing the appeal by just having this word in there. However, there's no justification for adding the word adjustable just from this Japanese. However, in the specification itself, in paragraph 17, it says this: Nao, joge ni takasa chousei kano ni kousei sureba, shioji ni koko no 作業者に最適な高さに設定することができる. So that is right there. There's adjustable. And there is a basis, there's support. There is definitely support in the specification for saying this, for saying adjustable. However, it's not in the original claim. So I think the point here is to know that these kinds of relative recitations relative to, I've talked about this elsewhere, I think not in the previous seminar, but in other seminars. Yeah, I did a talk about relative terminology. There's a section of the MPP that explains how relative terminology will almost always lead to indefiniteness rejections. And this is an example of relative terminology. And the problem is that, and this sagyosha is not a claim element. It's a human being. You can't claim a human being because you cannot make a human being part of your invention, no matter how much you might want to. You meaning the applicant. And in fact, the examiner said as much in more than once in rejections that the examiner issued. And the examiner said, the operator, or they use the word user, is not part of the claim. So when we say that there's a relative problem, it's because what is being related to in order to state the claim is something outside of the device that is not part of the device. It's not part of what's being claimed. So a really key issue for all of us translators to be aware of is to look out for recitations in claims that are relative to something outside of the device or whatever is being claimed. It can be a big problem, and it was a 10-year, well, let's say 8 years worth of prosecution time in this case. And it went on and over again. And the examiner kept saying, it's relative, we don't know how tall the user is, the user's not part of the claim, etc. But in terms of translation, I think these translations are all quite good. One thing, as just an aside, it's not very important, but oh, actually, I know, I do have the, let's take a quick look at the patent, original claim itself. The translation of what was it? Gosei Atsugami, I think. That was translated as here is claim 1 as it was filed here. It doesn't go to the next page. But they used the word stiff carton, which is very strange. Carton is a mistake. It should have the translator should have used the word cardboard. By the way, this would, based on in re oda, you could easily change the word carton to cardboard because it would be obvious the error would be obvious to anyone, not just a person skilled in the art. A carton is a three-dimensional, it's like a box, and you can't put a box, you can't feed a box into the paper feeding area of this large scale, this heavy duty printing device. In fact, the reason I put figure 3 here is to show you that 21 this is red gosei, right? Atsugami. This has to be a sheet. It cannot be a carton. And so the translator mistranslated Atsugami as carton instead of cardboard. Or there's a more sophisticated technical term I found it online, paperboard. Yeah. Oops. So anyway, unfortunately, that error was never corrected. After spending all these years and all this money and making many amendments, nobody thought to to correct that obvious error in the vocabulary chosen to translate that term, Atsugami. But others, and those of you who did the homework, you used rigid cardboard is pretty good. That's very literal. It's not a term of art, but it's very understandable and it's technically correct. Rigid board. I would avoid saying board without saying paperboard or cardboard because board itself includes wood and lumber, so you have to be careful. Board is too broad, actually, there. Rigid cardstock, that's cardstock, that's a great word. It makes perfect sense to me. I didn't know about that word. By the way, stock is sometimes a good suffix to use for zai, and you have so many words for material in Japanese, zairyo and buzai and shizai and zai. And instead of saying material all the time, native speakers will use this word stock. So I really like that as a suffix. Anyway, but only one translator used adjustable. This is fantastic. It shows that this translator probably read through the spec a bit or considered what the problem was. But everyone else did a good job with the translation. But as I also did, I just stuck to the original Japanese text, which I think it does not allow us to make the without telling the applicant and talking to the Ben Rishi or whatever and saying, look, there's a problem here. You have this phrase, Chosei Kano. Why don't we add that to the claim? Because this is going to be I would hope that from today's lecture, your awareness will be heightened, your awareness of this kind of issue, and you might be able to, if you have a good relationship with your client, you can say, well, I know from experience that this could create a problem, this kind of relativity problem. And then you could look in the spec or suggest to your client that they might want to revise the claim. I don't know if that is going overboard as a translator, but it's something to be aware of. The only other thing I would say is what I did, the sheet supply unit and everyone else did, is disposed at a height that allows an operator. I think this still looks relative, but is it better than what was filed? Here we have the paper feeding unit. This is the original English, being located at a height that enables a user to execute the paper feeding process. Is that any different? Let's see. From what our literal translation is. I'll just stick that in here and see. Is that any different? Let's see. Well, the only thing I would say is that the only argument I could make that this is a somewhat better rendering than the original English is that it's using the word dispose. It is disposed at a height that allows an operator. It doesn't say it's adjustable because that's not in the claim, but it's definitely disposed at a height that allows an operator. And it could be that, I don't know, I think it might have helped the prosecution. It probably would still be rejected, but it might have helped the examiner, or it might have allowed the examiner to give a more helpful rejection, because this English says the paper feeding unit being located at a height. This is like an afterthought, a kind of a comment. It's sort of like a where-in phrase. And it's saying it's located at a height that enables the user. I just think this makes the problem worse. The problem is still here, but I think it's a little worse because of this English. That's my concluding opinion. Okay, well, that's all I'm going to say about ex parte Miyazaki. We have come up on the first hour of today's 2-hour lecture, our seminar, and it's time for a break. So I will pause here for a 5-minute break and be back in 5 minutes, everyone. So I will unshare my screen and see you in 5 minutes. Okay, welcome back. I see I've got a couple of questions here, so we'll start with those. And I do have one more comment about the Miyazaki application, the claim. But let's see. The first question is, a height that enables a user と a height that allows a user の間には意味的が差があるでしょうか？それと、互換可能です。That's a really good question, actually, and it's obviously very important to translators. The first thing I'll say, I know it's not a direct answer, but is that allow is a synonym for enable. In general, I was just discussing this with a Ben Rishi translator recently. Allow, one meaning of allow is permit, and one meaning of permit is make possible. So there's kind of a chain of meaning there, but and make possible is synonymous with enable. But I would say an answer, direct answer to your question, Inoue-san, is that, or I'm sorry, Kami, I don't know how to read your name. I'm sorry. I would say that in direct answer to your question, enables is stronger, and I think it to me it implies that there is something more specific that is making something possible. There's something structural, something functional that is enabling. Whereas, like in this case, the height, I would say a height per se, a height is just, it's an abstract concept. It's not, I mean, an object has a height, but a height is a dimension. And I would not say that a dimension is really per se something that enables something to happen, whereas a machine enables something to happen, or electricity enables something to happen because it's energy. So the direct answer is I think allows is better in this case because of the rather abstract meaning of height. Does that answer your question? If not, I will be happy to try to give you a more useful answer. And again, I'm sorry, I'm not to not know how to pronounce it. Is it Shimoi or I'm sorry, I don't know how. But if that's okay for an answer, we'll leave it at that. If you want me to add something to that, I'm happy to go into more detail. Okay. So let me reshare. I said I was done with Miyazaki, but I forgot that I wanted to comment on this word ogata printer and the translation I came up with. Well, first of all, I want to say I would point out that simply saying a large printer itself is relative. This term itself is too relative. It's not clear. A large printer is, I mean, compared any printer relative to an ant or a grasshopper is large. So it's a relative term. This itself is a relative term. The reason this was not rejected is because the printer is the device itself that is being claimed. And so whether it's large or small is not important to interpreting the claim. It's just a name for the printer. In other words, the largeness of the printer, the large printer, the largeness aspect is not not a limitation on the claim itself. It's not a limitation. I should say the largeness of the printer is not it's not a limitation on the claim elements. The claim elements are the paper feeding unit and a printing unit and a discharge stacking unit. None of these units is large or small, so that's why the examiner let them get away with this. But because it's a relative term, I thought, is there something better that we can use? What I've done in the past, I used large scale, but that's also, it's just window dressing, as we like to say in English. It doesn't really change the problem of it being a relative term. Although by adding the word scale, it kind of, I like this word large scale as a direct translation of ogata because the scale kind of corresponds to gata, in this case, kata. And by saying large scale, it suggests that it's relative to smaller scale printers. But this time a term occurred to me that I have thought of in the past, and that is heavy duty. And I looked online, and I think there is such a thing as a heavy duty printer. And I think heavy duty, there is precedent, speaking of the word precedent, for saying heavy duty for ogata. I think there is translation precedent for that. So that's why, and heavy duty is a definitive category of printers. And if you look at the drawing and consider what this printer itself is, it's for using for printing on stiff cardboard and what was the other type of paper? Large sheet rolls, which I think is being shown in this figure. Yeah. So it's sort of for large scale, heavy duty printing operations, probably at, a professional printer's shop or something. Okay. So as I said, I didn't want to overlook addressing that they're talking about this ogata issue. All right, let's see. I think we'll go. Oh, I know what I wanted to do was to look at PTAB again. I'm afraid that when I started out today, I was warming up and not speaking very clearly or stating. I think what I was saying was rather jumbled, and I apologize for that. In talking about the origins of the decisions that I have found as topics for today's presentation. And so I want to go back to PTAB, the Patent Trial and Appeals Board, and just emphasize what this database contains. Let me say again. So going back to talk about the PTAB is to say that, and I've said this, but not very clearly, I will restate it once more. The Patent Trial and Appeal Board covers both trials and appeals. And what is the difference? So appeals are appeals from the examiner's final rejection, and those appeals are conducted solely by the applicant. They used to be in the name of the inventor, but now they're done by the applicant. And so they are ex parte, meaning they're only done by the applicant. There's no other party involved. It's just the one. There's PARTE party and there's PARTY, which are different. PARTE is this legal term that is used by lawyers, but it means ex parte means it's just on the part of on the side of the applicant in this case. And those are appeal proceedings. The other type of proceedings are trials, and trials are inter partes. Trials are trials for invalidity. And of course, a patent owner never wants to invalidate his or her own patent, or the company doesn't want to invalidate its own patent. So a trial for invalidity always involves another party. So it's between the owner and a party interested in invalidating the patent. And both kinds of opinions are in this database of board decisions. Board means the Patent Trial and Appeal Board. And if you can see here, you can sort by appeals and trials. AIA just refers to the 2012 law that established the trial system. Interference, I won't talk about that, but that was before 2012, before the US changed from first to invent to first to file. And there was these interference proceedings were when there was an issue about whether who invented something first. And that was kind of a between two parties type of proceeding. But anyway, the point is most of the decisions in this PTAB database are appeals because they are not an expensive, drawn-out process, and they can be filed by the applicant and who wants to try to overcome the examiner's final rejection. And so you can see in this column, most of the most of the proceedings are appeal. Well, there's actually a lot of trials too, but the reason I wanted to revisit that is in order to introduce well, it's not in another decision that I would like to talk about, and that is not here. Oh, okay. Well, yeah, I'm going to skip before I'm showing you the handout. I'm referring to the handout. We have this case, ex parte toru shimuta. It's an appeal that was initiated by the patent owner, the applicant, Murata Manufacturing. But before I go to that one, which is an ex parte case that is the subject of, involves the claims that are part of today's pre-seminar exercises, I wanted to go to this case, which is the result of, it's from a trial, and I'm calling it Daifuku versus Murata. And I give some background information about this case. So this was a inter partes review proceeding. It's a trial for invalidity, basically conducted within the patent office at the PTAB. And in this case, Murata had a patent, and that's here, entitled Automated Material Handling System for Semiconductor Manufacturing based on a combination of vertical carousels and overhead hoists. Very long title. And this company, competitor company, Daifuku Company Limited, wanted to invalidate Murata's patent. So it's interesting. You have two competing Japanese companies competing over a issued US patent. What is interesting, there's two interesting things, many interesting things about this case, but what is important, a couple of important points are, one, that this patent itself originated in the US. The research and the application itself originated in the US. There's no Japanese priority application for this case. So, well, why did I pull out this case? Well, because there's no in other words, there's no Japanese original application to look for translation issues with regard to the US patent to Murata. However, the reason this case is interesting is because Daifuku relied on one of their own Japanese patents in order to assert grounds for invalidating Murata's US original patent. So let me repeat. Murata owned this US patent. It was created in the US and patented in the US and had nothing to do with any corresponding patent in Japan. Meanwhile, Murata's competitor Daifuku decided that they wanted to invalidate this patent because it was probably getting in the way of, the devices and apparatus that they were producing and selling. So they filed a trial for inter partes review, It's a very expensive proceeding at the USPTO. I think the fees, the USPTO fees, are about $20,000 just to file the inter partes review petition. And the basis why Daifuku was, the reason they were confident that they could spend the $20,000 in PTO fees and then gosh knows how much in attorney's fees was because they had their own Japanese patent, Hei 1045213. This is an application. And they had a specific paragraph in there that they felt was provided grounds for anticipation, not obviousness, but just even anticipation that this patent application anticipated Murata's patent. And what is another interesting thing here is that this Japanese patent has no corresponding US patent. So there was no English available anywhere in the world. There was only this, a publication. I think it did issue as a patent. It doesn't matter whether it issued or not. The publication, the publication in Japanese itself can serve as a basis for anticipating any Paris Convention application in the world. So if you can find this decision online. It's available. Well, I found it in the PTAB database. But so this is the decision as issued by the USPTO's PTAB, and I'm just showing you to give you a sense of what these look like. Usually in the decisions, they tell you the outcome at the beginning, but if they don't, it's at the end. Yeah, it says, here's the result. It's at the beginning. It's usually in the first paragraph of these decisions, both the USPTO, PTAB decisions, and even the district court decisions. They usually give the conclusion at the beginning. And here it says it. Petitioner has shown by a preponderance of the evidence, petitioner is Daifuku, that the claims are unpatentable as anticipated. And Japanese patent application publication 213 is the same as this patent application. So that's basically what's going on. But I think was very interesting about this case in terms of a translation issue is that Daifuku referred to paragraph 7 in particular, and within paragraph 7, the key phrase was this Ido tai gawa ni mokerareteru. The whole, really, the entire assertion of anticipation hinged on this one phrase, Ido tai gawa ni. And the Daifuku had a translator that testified for this proceeding. I guess the testimony is submitted to the appeal board as part of the proceedings. And then Murata also had its own translator give a different opinion to try to counteract or as a countermeasure against Daifuku's opinion. And as I say here, a key contested issue was how gawa ni should be interpreted. Mr. Yazaki, so there was a Yazaki-san was their translator. Oh, he submitted they meaning the attorneys for Daifuku. I'm sorry for I'm sorry. This is Daifuku did not assert. Yazaki-san was Murata's translator. I guess, yeah, I think Daifuku was, in this case, Murata. Let's see. Anyway, let's go back. And let me just read this. Mr. Yazaki's declaration states that paragraph 7 expresses only that the transfer means. Oh, okay. So yes, this is Daifuku is saying this gawa ni means that it's, well, what it says here, the transfer means is on the moving body's side, as opposed to being on the article retaining side of the entire system, and not that the transfer means is on a lateral surface. Okay, so it does, this gawa ni does not mean that it's on the surface, but it means it's disposed on the side of the entire system. And I think all of us translators understand that this does not say, I guess, something like, oops, I don't know if you would say, yeah, I think you would have to say something like soku men would be on the side of, right? So it does not, the difference is between saying gawa ni and sokumen. That's how I would, maybe I'm wrong, but this is how I would describe the difference. But this gawa is a constant problem in translation. And the problem is that what is missing is that the system itself is not mentioned in this sentence, right? And this is the problem that we always encounter with gawa ni, and it means zentai ni taishite no nani kono gawa, hantai gawa janakute kono gawa, or whatever it is. And it's very interesting to me that the PTAB itself recognized, well, I should say Mr. Yazaki recognized and explained to the PTAB that that's what is going on with this expression. So I think what was happening here is that Murata was trying to say that it could include being on the side of, or maybe Murata's attorneys wanted to, oh yeah, because the Murata patent itself, there was some issue about whether or not this Ido Tai, the equivalent of this in the Murata patent, is actually disposed on the side of the system or on the side of a particular component of the system. And that was what the whole issue was about. And so it turns out that Murata's translator actually, he was very honest, and he said that the meaning here, it means, the meaning in Daifuku's patent means that it's disposed on the side of the system. Oh, that's what it is. So Murata's US attorneys were trying to say that, well, in the Daifuku device, the Ido Tai is what do they call it? Transfer means is limited to being disposed physically on the side of this component, or I guess, yeah, on the side of the Ido Tai. So the Ido Shudan is disposed on the Ido Tai. That's what Murata's attorneys were trying to say. But Murata's translator said, no, I'm sorry. We look at Daifuku's Japanese and we have to recognize that it's on the side of the entire system, not on a lateral surface of the moving body. So unfortunately for Murata, but fortunately for Daifuku, this very honest translator, Mr. Yazaki, looked at this Japanese and testified that this gawa ni means relative to the entire system and not on the side of the device. So I thought that was interesting, both from the perspective that this Japanese competitor relied on one of their own patents that had been only published in Japanese, and then actually and then filed this trial for invalidity of a competitor's patent. And both sides had translators. So Daifuku had a translator with who's not a native speaker of Japanese, a Chinese Japanese person or something, Mr. Chu. He's I'm sorry, I didn't read all of the details here, but yeah, I think maybe it was a different issue. So the point is they had translators on either side. Anyhow, so it's interesting that the whole issue of anticipation hinged on this one question, and because the translator's declaration was entered into the record and submitted as evidence, Daifuku prevailed and they won and were able to invalidate Murata's patent. Okay, so now I'm going to go to the homework once again, and this case, Murata Manufacturing, this is an ex parte case where this is a constant problem with applications, not just coming out of Japan. It's a problem in the U.S. with cases written in the U.S. I'm actually involved in a case originating in the U.S., being prosecuted in the U.S. I'm involved in the prosecution, and we got this kind of 1-2 punch. The first punch is the examiner says your claims are going to be interpreted as means plus function claims, or the elements. And then because we're interpreting them as means plus function, meaning I should say, because I, the examiner, am interpreting you, the applicant's claims as being means plus function claims, they are, and I'm going to look at this specification and I find there are problems with what is described, what the means plus function recitations in the claim correspond to in the specification is unclear. What sort of structure, what the corresponding structure is unclear. So at the same time, the examiner will issue a 112B rejection or 112A. So this is a double punch that's pretty common, a 1-2 punch, we say. And I think that's what happened here. Let me double check. Well, we can look at the decision itself, but these decisions are usually quite well written, and the judges or tribunal officials spent a lot of time writing very clear explanations of the history of the case and the result. So the appellant, in this case, again, Murata, appeals from the examiner's decision to reject, and they affirmed the examiner's rejection. Why was it? So what is the rejection? So we have claim 1, which is part of today's homework or pre-seminar exercises. And what happened was that the examiner made these means plus function recitations under 112F, and then they tried, and on that basis went through all on an element by element manner, looked at each of the elements being interpreted under 112 to see if there was sufficient corresponding structure, and didn't find it. So well, I guess, yeah. Oh, okay. So here we have the 112B rejections of the claims. But anyway, what I wanted to do was just look briefly at this as a translation issue. Could we as translators have done anything with this? So this is from the decision itself. There's the 3 key elements in question were a posture detector, a classifier, and a fluctuation identifier. And these are, and so these are the results. Well, let's look at the homework before we look at the board's conclusion on this appeal. So I gave you quite a bit of background here. It's very interesting that the spec was the specification drafters very diligently provided these expressions where they said, nantoka no shudan toshite kinou suru. So that this expression appears, which, it's clearly an attempt to say that this particular, hopefully structural feature corresponds to some means means recitation in the claim. And so that pattern is repeated right through in these different paragraphs that I cited. So you have similar thing here. Kasoku do sensu wa. And then in this case, shisei kenchi shudan to shite kinou suru. So, well, anyway, you get the point. So the question is, I asked everyone as a translation exercise to instead of to not use the word means, and so if a situation in which this is possible would have to be an ordinary Paris Convention based priority application based on Paris Convention priority, not a PCT application. If it's PCT, of course, you have to use the word means if it's in the claim. But the assumption here is that it's a pariurut, as you say in Japanese case, and the client said, "Oh, we don't want to use the word means, so please use anything besides means, and we'll try to avoid getting a means plus function interpretation from the U.S. examiner." So that was the challenge here. I think this is very good to use circuitry, or that's a good attempt. But there is case law that using the word circuitry itself as a substitute for unit might not be sufficient enough to overcome the presumption that it, or the interpretation that it's just means plus function. Posture detector. Let's see. Oh, so these are the three. Yeah. So we have each translator did for each of these three. So we have calculation circuitry, detector, categorize. There's sorting circuitry configured to sort. So circuitry, and then detector. So the problem with circuitry, it can work, but you have to at the same time claim a processor that configures, or on the basis of which the circuitry is configured. Otherwise, the circuitry has to be a well-known device, in this case, a circuit-based device that would be understood by a person skilled in the art to have, like, for example, maybe a converter of some kind, or a variable resistance circuitry, or you'd have to have some well-known kind of circuitry. You can't just throw in the word circuitry and hope to overcome the interpretation as a means plus function element. But these are good tries, and I think everyone, did well. I mean, as well as can be expected. And the other option instead of circuitry is to use, either OR or ER as, endings indicating a device of some kind, right? So classifier, detector, etc. Obtainer, the problem is that, again, it has to be a structural. If it's not described in a specification as having, if the specific structure is not described, it's probably going to be interpreted as just a means plus function. So, but these are all very good attempts, and they're all very good translations. What I did, I did basically the same thing in my model translation. I'm sorry, I did some more. I went beyond. Understanding that circuitry is probably not going to work, and just adding OR or ER to the verb, the functional verb, is probably not going to work. I dug a little bit deeper into the spec, and what I did here is I used the word gauge because we have a keisokubu. I thought that it might be fair to call this a gauge, but the problem is that if you look at the drawing itself, it's just like 330, I think. Is it on here? It's yeah, it's within 3, which is just a, well, this is the Ketsuatsu Hendo Suite Sochi, but oh, Shingo Shori Bu. So it's the 31. Yeah. So here, like, for example, 330, the Jikan Keisokubu is within 31, which is just a signal processor. So, but I thought maybe this might work if like using the word gauge is a very specific device usually, and it might be interpreted as a specific kind of circuit that would be understood by a person skilled in the art. That would be one possible trick, but it's going a bit beyond the Japanese, and I would, this kind of change I would have to I would say any translator would have to explain to the client. Acceleration. Oh, for this Shisei, what is it? Shisei Kenji. Well, we already have acceleration sensors, so that's fine. Oh, I just added the you could keep the adjectival modifier there, the participle. Classifier, that's just adding ER. I don't think this is probably not going to be successful as a way to avoid means plus function. Then for this one, I did a literal translation, and to me, that's again this ER acquirer. It's not going to work. So as I started to say, I dug a little bit deeper, and what I found here is that by looking at the spec, what's going on here is that I think in some place in the spec, it describes, well, it says here GK 列 data に基づいて. So I thought that we could call this Hendo Shutokubu, we could call it a time series analyzer, and that might work as a way to avoid means plus function interpretation. But anyway, in any case, on appeal, the board went through every element and basically said that the only well, there's only 3 elements, but among the 3, only detector is acceptable as overcoming means plus function interpretation. The others were not successful in overcoming means plus function interpretation. So unfortunately, the problem is ultimately a claim drafting problem. And in very briefly, the way that this is the means plus function problem or interpretation is overcome requires claiming the processor itself and saying the processor is configured to function as this kind of circuitry and that kind of circuitry and the other kind of circuitry. If you do that, the processor is part of the claim, and then the processor itself is considered sufficiently structural, and it becomes a unique processor by saying it's configured. It used to be you would have to say it's programmed by particular kind of algorithm, but now the PTO is a little bit more forgiving about that. So as long as, in my opinion, what would solve the means plus function interpretation issue is to claim the processor. But unfortunately, the original claim does not include the processor as an element. So because it does not, the means plus function interpretation of those second 2 elements, this one is okay, but of the Bunri Shudan and the Hendo Shutoku Shudan, those are there's no English trick, word trick that can overcome that interpretation. Okay, I want to be mindful of time here. I'm going to just speak about this homework very briefly. I don't have any PowerPoint about this. The reason I included this is because, excuse me. included this claim is because this also was the subject of a means plus function interpretation. And I think this case was also appealed, and I think the applicant lost on appeal, but I don't have time to look at the decision per se. But again, I guess what I wanted to illustrate to everyone by citing these paragraphs from this case is that this case also describes a processor. Oh, and let's see. Well, at least, yeah, it claims an image processor. That might have been, yeah. And then, so we have Gazo Shoribu, but then this one is just a Keiro Shutokubu, which is probably, there's not definite structure for it. I think that these processors are going to be okay because they're claiming the processor itself. The problem was the course acquisition unit. That is going to be interpreted as means plus function because there's no specific structure that's clear to a person's skill in the art that can carry out this function. But let's see what everyone did with the homework on this one. Image processor configured to generate. Good. Displace. Yeah. Configure to in response superimpose an image. Yes. Yeah, so I think everyone did a good job with the translations. The idea was to explain that we as translators, our hands can be tied as to what we can do in terms of improving the translation to the extent that it might be insulated against a means plus function interpretation. A couple of quick comments though about oh, this is good. I wanted to talk about the Kankyo Gazo deshitake. Let's see. Yeah, Shuhen Gazo. So this is good. A surroundings image. So the surroundings, the best translation makes, if you just say a surrounding image, that would be incorrect because the image itself would be surrounding something, or the image itself does not surround the vehicle. The vehicle has surroundings, and then those surroundings are imaged. So that distinction is really important here. And I did want to look at that. So this is good. It makes that distinction. Unfortunately, this is saying surrounding image, so it makes it sound like the image is surrounding something else, which is not the case. Image of surroundings, that's also, yeah, so I should maybe make this a different color, eh? But this, yeah, so this image of surroundings is what we're looking for. Surrounding image is not what we're looking for. Image representing a surrounding state. Yeah, that's also. So this indicates a technical awareness, which is something that we should all, as translators, have as part of what we do. Image showing a situation around. Okay, that's also fine. Surround image. Okay, that's kind of in between, but I think this is good. This will still be acceptable as modifying the word image to say what kind of image rather than where the image is. Okay, again, being mindful of time, I'm going to stop here. I would say, unless, if of course, if you have questions about this translation exercise, I'm happy to answer them. And then I'll just, before I finish with the slides and to conclude the seminar, I just want to look at this last one. I did this kind of for fun, this shomo, how would we translate that? And everyone seems to be aware of the problem here. This is what I did, a gene of interest. Where is, let's see, major, yeah, or target. Okay. I think target gene is also fine, but I think that Shomo is, target is not as direct, is not as faithful a translation of Shomo as of interest would be. That's in my opinion. Specific gene, okay. Intended target selected. These are all acceptable. What was interesting about this case is that I just thought I would throw it in there to show what kinds of problems can arise. The examiner said that the translator translated Shomo very faithfully. Shomo, is that the right pronunciation? And as desired. And the examiner said, well, I can't highlight. The examiner said it issued a 112 rejection, 112B rejection. Say, claim 1 is considered vague and indefinite for the following reasons. In claim 1, the term a desired gene is unclear and confusing. It is unclear as to what is considered a desired gene. So I thought that was interesting that this came up. I think this case was also the subject of, no, it's not the subject of an appeal. It was a 112 rejection. I forget how I found that. But anyway, so everyone did a good job of, none of you translators who did the homework would have had this rejection, or your translations would not have resulted in this rejection because you did not use the word desired. So very good job. All right. Now so that's really it for the pre-seminar exercises. And again, if you have any specific questions, I'd be happy to answer them. But I'm going to turn now to conclude with just a few more slides from my PowerPoint presentation. And then leave a few minutes at the end, hopefully, for any questions, because as I say, questions make turn a lecture into a seminar. So there's one other case that I threw in here that I did not put into the handout, but I think it's quite an interesting case. And it's, frankly, as a translation issue, it's rather difficult. So let's look at it together for a moment. This is actually a district court. I think this was actually a patent lawsuit. So this company called Tuna Processors is actually a Japanese company that has a process for smoking maguro, tuna, to give it a special kind of taste. And they asserted infringement against Hawaii International Seafood Company. And interesting enough, most district court patent lawsuits are handled in Texas in part because of juries there are partial to the patent owner. But this case was in the District Court of Hawaii, which is very nice. Be nice to be a lawyer who gets to go to Hawaii and argue a case there. But so here's the statement of the case from the decision, and it just outlines what Claim 1 describes. Claim 1 is what the claim that was one of the claims at least being asserted by tuna processors against Hawaii International. And the English claim, the claim in English has these 3 steps as constituting the method of smoking tuna: burning a smoking material and passing the produced smoke through a filter, cooling the smoke passed through the filter to between, I'm sorry, it should say, well, I can't, oh, okay. Anyway, cooling it to between 0 and 5 degrees. I'm sorry, there should be a space there. Between 0 and 5 degrees centigrade, and smoking the tuna meat by exposure to the smoke cooled. So the issue here is about participial adjectives, and I will conclude with one other very, very brief look at a case decision about that. And oh, I'm sorry. I will just very briefly refer to the handout. I did put this um, statement from this case. This has nothing to do with a Japanese applicant or petitioner or defendant. But it's interesting because the case talks about participial adjectives. And in this case, the word folded. And in particular, folded to form, which is a very typical kind of recitation you might see in Japanese, oritatande keisei suru or something like that, right? And I won't, I would just leave this as a reference for you to look at, you translators. What was interesting about this case, which was in the U.S. District Court of Illinois, the court said folded is not a process limitation, it's a structural limitation, even though we have the word to form, which makes it sound like it's a process limitation. They very clearly said that neither contains a process limitation. The district court in Illinois said very clearly, folded just means folded. It's a structural limitation. It's not saying that in this case, a window shade had to be formed by a particular kind of process of folding. So it's interesting because as translators, we have to pay attention to whether we say was folded, is folded, has been folded, is being folded. We have all the different tenses that are available in English. And basically, my advice to jump to the conclusion is unless it's very clear that you have to put some kind of time aspect to the tense, just use the simple past tense, past participle, in this case, folded. And I'll show you one more example of that in just a moment. But here, what was interesting is we have produced smoke and cooled smoke. In this case, smoke cooled to this temperature. And we don't have time to go into more detail, but the Hawaiian District Court, which is actually, the district court is not in Hawaii itself. It's a circuit court. It covers Hawaii and Alaska and California, I think. They said the first step, the smoke is produced. The use of the past participle confirms that the smoke must be produced prior to. So they're saying in this case, it's a process claim. And so there is a time sense. Produced means it's produced prior to the next step. And then the smoke is passed through a filter. And again, the past means that it occurs after the next step after past is means that past happens before the next step, which is cooling. And then finally, here, the use of the past participle in the smoke cooled, and that was the disputed step, and it requires that the smoke have been cooled. Requires that the smoke have been cooled. This is a special grammatical construct. To have been cooled is what it means. Prior to contacting the tuna meat for an infringement to occur. So what happened was Tuna Processes, the Japanese patent owner, tried to say that Hawaii International was infringing their patent because the smoke did not have to be cooled necessarily in the order of the steps that were recited. And I will just leave you with this as translators. It's interesting to look at the original Japanese claim, which I looked up, and compare it with the English that was rendered. There are some significant differences. I would say the translator took quite a few liberties. It's very clear that hase saseta is kun en o filter ni to shite. It's clear that this is just saying generated smoke is fine, so that's the same as produced smoke. But the key here is that really this Japanese claim doesn't really have any clear steps. That's kind of a big problem in terms of how the claim should be rendered and how it will be examined in the US. But what I see as a really interesting and big problem here is to shite for 接触させる, they just used exposure. I guess that's the same. Exposing it to the smoke is the same as contacting it. But冷却し、で、0から5セルシーの訓煙通して、この当細物に、対象物に接触させる。So the question is whether the smoke has been cooled and only has to have, it can only have already been cooled. If you say, 訓煙通して, I guess so, but I think that this could have been translated differently and it might have made the claim broader. Let me just conclude by saying that. I don't have time to go into more detail, but I think this is a very interesting case where the translators took too many liberties and maybe made the claim narrower than it needed to be. And so the patent owner, tuna processors, was probably looking at the original Japanese claim and thinking, well, we should be able to assert this against Hawaii International Seafood. But then when the claim was actually analyzed, the claim in English by the district court in the patent infringement suit, they interpreted it correctly according to what I would say is probably a narrower interpretation than the original Japanese warranted. So I'll leave that there. And then the last thing I'll talk about just for 2 minutes here is this case. This has nothing, again, has nothing to do with Japanese applicants, but it just shows you how important grammar can be in patent lawsuits. And this is from this case, TQP Development versus Intuit. It's fairly recent. It was issued in 2014. I'm not going to read through this, but I would encourage you to read these just 2 pages that I excerpted from this decision. It's interesting. So claim construction, this construction, I've talked about this elsewhere. Construction has 2 meanings. One is to build something, koji suru or what, but the other is kaishaku. Construction is the noun form of construe, and construe means interpret or kaishaku suru. So this claim construction is always a essential proceeding in any patent lawsuit. It's in particular, it's the result of what was called the Markman decision. It was in the 90s. A famous decision was issued, and it said in patent lawsuits, the first step should be for the court, the judge, to interpret the claims, make a legal interpretation. In a U.S. proceeding, there's legal versus factual issues, and factual issues are decided by a jury. All legal issues are decided by the judge. So claim construction is an issue for the judge. And in this case, the key issue was how to interpret the word are transmitted. I didn't underline it here, but the court's construction of the phrase are transmitted. Should it be are being transmitted, or should it be have been transmitted, or could it be both? And it turns out that the tense of the word are transmitted, does it mean are being transmitted or have being transmitted? That grammatical issue was the entire question that whether or not there was infringement hinged upon. In other words, the accused infringer was trying to avoid the accusation of infringement by splitting hairs over this grammatical interpretation. The defendants argue that are transmitted must mean having been transmitted. And then this is the Federal Circuit, I think, and they said, no, are transmitted covers both possibilities unless there is evidence to the contrary. So that's all here. It's a very interesting case. I will polish up these slides to make it, add some underlining so that you can, if you would like to look over these slides after the seminar, you can see the important issue that I wanted to highlight here, which is the simple past participle in absence of any evidence to the contrary or within whatever you're translating, if there's no time implication or no nuance or a definition of present or past or like having been translated or is being translated, being transmitted, then just use the simple past tense and you'll be okay. That's the point. All right, so that's it. I'm going to just wrap up by saying, giving you the takeaways that I hope you take home today from the seminar. Number one is that, so I'm just wrapping up and sort of reviewing what I talked about today. Under the U.S. legal system, case law plays a central role and can quickly influence how administrative organs, gyosei kikan, function. Second takeaway is that translation issues as well as grammatical issues have come up over the years in both U.S. PTO proceedings and in the federal courts over patents. Of course, this is all about patents. And not just translation from Japanese to English, of course, there are many other translation issues from other languages have also appeared in case law. One of the most important points, and I hope you understood that from ex parte Miyazaki, is that translation problems can have a costly economic impact on patent prosecution and enforcement. And even in the tuna processors versus Hawaii, whatever it was, international seafood, they lost. So they lost the chance to receive very large sum in damages, tuna processors. And arguably it could have hinged on a translation issue. But if not, at least we know, like in the Murata cases or in at least, yeah, in Daifuku versus, well, no, that was okay. They didn't lose money because of the translation problem there. So, but mostly I'm talking about the ex parte Miyazaki case. And then lastly is federal court decisions discussing and giving guidance on grammar can provide useful rules to translators. And in particular, today I was talking about the past participles, but also means plus function issues. I hope that you understand from the appeal board decisions I looked at that it's very difficult for us as translators to avoid means plus function interpretation without going beyond the language of the claim itself. But if you have ideas about that and you want to suggest them to your client, you might wish to do so because most applicants in Japan want to avoid means plus function interpretation, in my experience. So, and then the last takeaway is we translators should be aware of these precedential decisions like in re Oda, ex parte Miyazaki, and some of the other case law that I talked about today, for example, how in the Daifuku versus Murata, the Sokogawa ni, I'm sorry, not Sokogawa, Nantokagawa ni, that translation issue was very important to that case. And so these kinds of issues, it might seem, at the time, like you don't want to spend too much. It might not seem that important, but it turns out it could be extremely important and have a huge impact on patent prosecution and enforcement. So I'm just this is the same series of takeaways. I just put it in another slide to have it there for everyone in the version of my presentation slides that I will provide you after the seminar. So thank you. I'm going to check my chat. I don't see any questions, but I have 5 minutes or so. If anyone has a question, I'd be happy to answer. Close.
皆様ご質問などございませんでしょうか？
Okay, or no okay? Yeah, if anything was unclear, I mean, I'd be happy to try to make it clear, or if there was any question on the pre-seminar exercises on the translation, I'd be happy to answer such a question. No? Okay, well, if there aren't any questions, then I will leave it here and stop sharing my screen. And thank you once again for uh, attending today's seminar. I appreciate it, and I appreciate the opportunity to give you this presentation. Frankly, I really enjoyed looking into these case law decisions. There are many more. I didn't cover nearly all of them. There are several others that I found that I would enjoy talking about, but obviously that would uh, extend the seminar way beyond the allotted time. But my point, I would just like to conclude by adding that just because I only covered a few case law decisions involving Japanese to English patent translation doesn't mean I covered every decision. I I found at least maybe half a dozen others, but I didn't choose them for today's presentation. So the point is, it's an ongoing issue, and we translators can have an enormous impact on patent prosecution, well beyond just the application stage, but which means our translations can have an impact on appeals from final rejections, as well as trials within the patent office and then trials within the federal court system outside of the patent. Okay, so then I will stop here if no one has any questions and turn off my screen sharing and turn it over to you, Irie-san.